From a man getting sentenced for his unimaginable abuse against children,
each child victimized is entitled to their individual accountability for their loss of innocence, the harm that was done to them. It just seems improper.
To another facing charges for evading court appearances.
It's ironic he's on probation for evading arrest or detention, and now he's evading appearance or detention with us, in kind of an ironic twist.
Here are 3 moments where Judge Stevens ensures offenders face the consequences of their actions. Starting with the disturbing case of Mr. Brown. Here we have a man guilty of contentious sexual abuse, shamelessly trying to justify his actions as historical. Let's watch the judge handle this.
2-9, the state of Texas versus Mark Dwayne Brown. The defendant was earlier found guilty in each case of the first-degree felony of continuous sexual abuse of a child in each case. Today, punishment phase began. Evidence was presented. The jury was instructed. They have deliberated. We have received a message from the jury that the jury has reached a verdict in this punishment phase of these 2 trials.
Approach you?
Yes.
There's the certification.
Mr. Brown, on each of these cases, do you understand that these are not plea bargain cases, and you have elected to have a trial by a jury and a decision by a jury on punishment as well as guilt or innocence, and thus you have a right to appeal under law these verdicts and judgments. Do you understand? All right, I have signed the to appeal certification. Please bring the jury in. Thank you. The record shall now show that the jury is in the courtroom as jury foreperson. Am I pronouncing it correctly? Is it Swear or
Yes, sir.
Swire?
Swear.
That's I grew up with some Swears in Mid-County, and that's the way they pronounce their name. Now I think I called you Swire, but Miss Swear. And thank you for your accepting the job to be foreperson of the jury in these cases. We have received a message on behalf of the jury that the jury has reached a verdict in these 2 cases that the defendant was found guilty of, and for which he requested the jury determine punishment in each case. Is that so?
Yes, sir.
Are these decisions unanimous ones? That is, ones that are agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree with your foreperson's representations? No disagreement. Please, as before, I'm going to ask you to pass the documentation to the bailiff. You may be seated. I will review for proper form and publish the verdict in each case. And the defendant is now standing with his attorney in cause number 21-36727. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years, signed by the jury foreperson. In cause number 21-36729, the verdict is as follows. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years, signed by the jury foreperson. These verdicts are received and made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, your duty as jurors is complete. At the beginning of the trial, I placed each of you under a number of instructions. And at this time, I am releasing you from all those instructions previously given to you. However, one additional instruction Once you are discharged, you are released from your oath of secrecy and you are free to discuss the case and your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by the court. Now, once you are discharged, I've got to deal with some matters with the attorneys, and they will be released shortly. And they always like to talk to jurors to get feedback from them. It helps them to become better lawyers. Sometimes it's this is what we like, this is what we didn't like. Why did you do this? Why? Yeah, and you are free to discuss that, Martin. You're also free to go home, but they will be released and they will be outside if anyone it wants to discuss any of the matters with the lawyers. These are very fine lawyers, and it's always an honor working with them. And of course, you are free to discuss or not discuss. In just a moment, my coordinator is Ellie's going to be out there. She has documents for you that shows that you were here, that you can use for work or school or other purposes. It is always an honor to work with my fellow citizens of Jefferson County, Texas. In this court, these decisions are never easy, and they're not supposed to be, because your decision determines what direction all people involved in the case are going to take from here on. What we have is the rule of law. As long as we follow those rules to the best of our abilities, then things seem to work out. I wish we didn't have crime. I wish we could all live happily together and there weren't people hurt and weren't people who make mistakes. Everybody makes the mistakes. All of us are hurt at some time. And it's how we deal with those mistakes as a civilized society under the rules of law, which we talked about in the preamble, are very special attributes, just as though our Creator had intended, as we believe from the Declaration of Independence to the rules of law, that we can all live together happily as best in spite of the fact that mankind is imperfect. I feel you took your oath seriously. These are difficult decisions, and I want to thank you on behalf of this county for the time and effort you placed in your decision making. May God continue to bless Jefferson County and her citizens. And with our profound thanks, you are excused. And alternates, thank you as well for being ready, willing, and able. We have been using alternates in the last about 1 out of 3 or 4 trials. Alternates are needed. So thank you for your efforts as well. And again, the attorneys will be outside shortly if you wish to speak with them for any matters. And again, thank you, and you are excused. Thank you, Ms. Swear, for your work as foreperson. Thank you for leadership.
Thank you.
It's a true gentleman who holds out and waits for everyone else and goes last. All right. Is there any reason why formal assessment of judgment of the court should not be made at this time? Mark Dwayne Brown, you came before this court and a jury, entered pleas of not guilty to these 2 cause numbers, 21-36727 and 21-36729, 2 indictments, each charging you with the first-degree felony of continuous sexual abuse of a child. You entered pleas of not guilty to the offenses as set out in each indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned verdicts finding you guilty of each of these offenses, these first-degree felonies in each of these cases. Then evidence was submitted, the jury was charged, and after deliberating for punishment, deemed your sentence in each case should be imprisonment for 40 years confinement. Anything to add before the court goes further?
None.
It is therefore the judgment of this case that you are indeed guilty in cause numbers 21-36727 and 21-36729, two indictments charging you with the first-degree felonies of continuous sexual abuse of a child in each case, and that you shall be punished in accordance with the jury's verdict. Giving the defense an opportunity to express any legal reason why sentence should now be pronounced against the defendant, the defense has elected not to add any additional information. It is therefore the order of the court in each of these cases that you, Mark Dwayne Brown, having been judged to be guilty of the offenses of continuous sexual abuse of a child in each case, first-degree felonies in cause numbers 21-36727 and 21-36729, and whose punishment has been assessed at 40 years confinement in prison in the Department of Criminal Justice Institutional Division for each case, that's 40 years confinement in each case, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined in each case for 40 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Now, the law provides that these cases, the sentences in these cases, can run concurrently or may be ordered to run consecutively. Everybody be seated. What says the state of Texas, please?
Your Honor, we are asking that these cases run consecutively due to the amount of children that were harmed in these cases due to the allegations made by both Rebecca Loop and Mackenzie Brown in this case of being continuously sexually assaulted by this man, the amount of years that this went on. The fact that these happened for the youngest child was 6 and the oldest child was 9. These are truly heinous things that this man has done. Because of all of these things, the state is requesting that these cases run consecutively.
And defense.
There are several arguments. One is that you're looking at something that occurred 12 years ago. There was nothing after that, it was a continuing threat. In addition to that, Judge, this is a day-for-day sentence based under the law of continuous sexual assault. My client is 42, 43 years old, so that places him in the mid-80s when he is first eligible. And I believe that that is sufficient punishment of whether or not he will be out of prison when he's 80+ years old. And we would submit to the court that 40 years day for day is sufficient for justice to be done in this case.
Anything else?
No, Your Honor.
All right. A couple of things before the court renders its decision on this is that the law provided by the legislature enactment in the penal code for violations under section 21.02, continuous sexual abuse of a child, which again involved the following elements during a period that was 30 or more days in duration, when the defendant was 17 years of age or older, commits 2 or more acts of sexual abuse against a victim younger than 14 years of age, and the offenses alleged to be committed in these cases that were proven true and found, and a jury found guilty, involve aggravated sexual assault of a child and indecency with a child in cause number 21-36727, and in 36729, the crimes committed were indecency with the child. Each of these are first-degree felonies, and the law provides that a violation of this offense is punishable in this way of no less than 25 years, no more than life imprisonment. The jury assessed in each case a sentence of 40 years confinement as punishment for each case. And the defense, wisely as he always is, and this court is always fortunate to have most worthy practitioners for the state as well as the defense. But what Mr. Burbank argues is this is something that is historical, and there is no proof that the defendant has since then been guilty of wrongdoing other than what we know about that was introduced and admitted at trial. But there is a truism. What is in the past is never, ever really in the past. And each child victimized is entitled to their individual accountability for their loss of innocence, the harm that was done to them. It just seems improper that if in circumstances such as this one, if these sentences were not to run consecutively, that is, each child's harm was not dealt with individually rather than packaged together, it just wouldn't seem fair. Otherwise, the message that's sent is, if you're going to commit this crime, go all out and get a lot of victims, and you'll only be punished once for the victims. They'll package it together. These are human lives, not only the defendant, but the harm that was done to these children. These are children. Each child has her own harm that is special and unique to her from each of these first-degree felonies of continuous sexual abuse of a child. I wish Mr. Brown would not have committed acts for which the jury deemed beyond a reasonable doubt he did, which were first-degree felonies for which the state of Texas carries with it the potential of really probably the most punitive type of punishment next to capital murder, and that is lengthy sentences of a minimum of 25 years without possibility of parole. But the statutes are written for each victim. Each victim has their right for what they have lost to have the wrongdoer answer to that particular person's harm. And here, two individuals, and once again, the terrible message would be conveyed: if you're going to do this, well, harm a lot of children, you'll only be punished as though it were one victim. And that's not the message that was intended by the legislature. That's not what the circumstances of these two cases call for. Thus, the court is going to order that these sentences run consecutively to each other. So, 21-36727 and 21-36729, these sentences shall be ordered in accordance with the jury verdict to be sentences of 40 years confinement in prison. And that the sentence in 21-36729 shall begin with when the judgment and the sentence imposed in cause number 21-36727 has ceased to operate. And in other words, that these sentences shall run consecutively rather than concurrently. Is there anything else the parties need to add or bring up?
Nothing from the state, Your Honor.
And defense.
Just for the record, Judge, the defense objects to that.
All right, the defense, the defense objection is noted and made a part of the record.
While Mr. Brown was sentenced for the horrific abuse of minors, here's Mr. CJ, involved in a violent robbery, shamelessly asked the court for leniency to avoid serving his full sentence. Let's see how the judge responds to this audacity.
Go ahead. In this case, this is 22-40835. You are Karan Joseph Dickerson, also known as CJ. And you are here with your attorney, Mr. Gertz, and the state's attorney. And we are here, the defendant has filed a motion to suspend upfront time. I ordered 180 days upfront time. How much time have you served now? How much time does it on this? September? About four months.
And Judge, the purpose for the filing when I filed it was in an effort to see if the court would let him go here for Christmas. Obviously, we've missed that vote. He's got 2 more months that you could hold in suspension. We'd ask you to consider doing that, but primary reason was for him to be home with his family for Christmas. He understands the seriousness and the nature of the offense and his participation in it. While it was a less dramatic role than some other players had in the incident, he certainly played a serious role, and he takes that very seriously. And his intention, his plan is to, whether it's now or in 2 months, to get out and be successful on probation and put this behind him and do well with the opportunity he's been given by the state and by the court.
So, okay. Anything?
He's lucky to be alive because the shootout that happened did kill one person, which was involved in the robbery, and wounded another that was their robbing. So,
And he was involved in all of it.
he was involved in all of it, but he did not fire a shot, to my understanding. And that's why we
But as a
dismissed the
party-
murder case.
Okay.
But he did participate in the aggravated robbery. Yes, sir.
Okay. Well, isn't that capital murder?
It could have been that was what it's originally charged.
That's the way I read
Yes.
this.
Yeah.
I mean, this could have been,
Yes, sir.
I'm reading the probable cause affidavit, and for whatever reason, the state preferred not to pursue capital murder, but you would have had 2 choices: life without parole or the death penalty. Those would have been the only options. So I'm reading this, and Mr. Gertz is just fabulous lawyer, but he can't make something out of nothing here. And So you were involved in a robbery where someone was shot, multiple gunshot wounds to the body, this states. As- Apparently you were in a navy blue polo jogging suit. Correct me if I'm wrong, but is that right? Yeah, that's you. And you entered the residence, displayed a weapon. The co-defendant, Randall Cormier, told you, CJ, that's your name, is you clean this up, and forced all the occupants inside to lay on the floor. You then collected the cash and the illegal drugs from inside the residence. So, prior to leaving the residence, Cormier produces a black weapon. During the time the victim produced his own handgun, there was an exchange of fire. Cormier and CJ flee the scene in the white four-door Nissan Altima. Cormier was transported to a local hospital with gunshot wounds and died. So we have one man who dies, who was the most bad guy, I guess.
Yes, sir.
Most culpable here.
Yes, sir.
Then we've got Derek Gilbo suffering multiple gunshot wounds, who was one of the victims who was being robbed.
Correct.
In my position, being answerable to the people, it was placed into my lap. The state felt like, for whatever reason, that they always seem to try hard to be fair in the cases. They felt like, in spite of what would be called a real disturbing violent crime in this county, which we have all too often, they felt like deferred or unadjudicated probation was the best thing of all the circumstances. So this court, in manufacturing a set of conditions that you would be required to follow, that not only helps you fix your mistakes and your mindset, because why anyone would think this was a good idea to participate in is beyond me. But you have been given a really rare second opportunity to fix all this mess and do better. So one man dies. One's got to be critically injured with multiple gunshot. I don't know how you can get multiple gunshot wounds and not be in critical, but serious at least. You're participating in this, and if technically you could have been charged with capital murder, and if the victim would have died, one of the victims to this would have died of the robbery, you most certainly probably would have been. So you got a break. When I sentence you, we have terms and conditions, and then you are essentially free, a free man, except for those conditions that are placed. One of the conditions is I can assess confinement up to 180 days. And I'm sensitive about doing that because sometimes one day is all people need. The point is addressed and they understand and they don't want to ever go to jail. But it's not only the message I send to the person who's the defendant, but it's also what I send to the general public and the people who say, is this county being run in an efficient way by the people who help run things? And when people are involved in crimes of violence where one dies and one's has multiple gunshot wounds, how do we deal with that? And 180 days is the most I can assess. I can't even imagine, in thinking about it, what set of circumstances like these set of circumstances, how anything but 180 days should be assessed. Just because people want to know, okay, so what does it take to get 180 days confinement? How many people have to be shot and killed in a violent crime? And you know better. I think Mr. Gertz said, you have a family at home?
Yes, sir.
Who?
A girlfriend and two little boys.
Two little boys.
Sir.
Two little boys. Well, you missed Christmas, didn't you?
Yes, sir.
They missed Christmas. How old are they?
9 and 8.
Look, what's the greatest gift you could have given them if you would have been home at Christmas?
Being a father, son,
Setting a good example, because children are going to emulate their parents. It's a natural phenomenon. They do it. If you are a bad role model, they're liable to turn out bad. But they're going to do what you do. So you can't be surprised that when they are teenagers, they're going to be running around with guns and shooting at people. How proud would you be about that? Because they would have learned it from you.
not proud at all.
All that being said is this, is 180 days. It's not even, this isn't even a close call for me. I've got to set a standard. If people are going to be fortunate enough in these circumstances to get deferred or unadjudicated probation, they're still going to have to pay a price to set the example, not only for you, for others and your children too, even though they're without their dad. That was your fault. You caused that. You ought to regret it for the rest of your life. Really going, there was a Christmas that the children had without me because I was mixed up. This is drugs, my God, drug dealing. If I were you, when you get out of jail, you need to embrace them and try to put into actions what you ought to be feeling. And that is the love of your family and this close to an absolute loss to that family that you had if you wouldn't have been able to work this thing out in a fashion that really is remarkably generous for you. Because this is how close you were to the death penalty, this close. But I've got to set a standard, and this isn't even a close one. Yeah, your lawyer's trying, but you got to pull the weight by your actions and the decisions and choices you make, sir. You have a family, you need to be thinking of them first whenever you're making choices like this foolish decision. 180 days is terrible. I wouldn't want one day in the jail, but you're getting out in a little bit of time. You're not going to death row, which was an option here, sir. Hopefully you're scared to death about how close you got to losing your life, your freedom, your family, and their father. Get out. When you get out of this, follow the terms and conditions of probation, because look, you fail on probation, you're looking at life and up to life in prison. But all we're doing is saying, follow the rules, act responsibly, that I have to do. This is the same rules I have to follow, really. And I'm not accountable if I don't follow them. But you just have a probation officer who's going to help you get through this. You put yourself number one. And you're a religious guy?
Yes, sir.
You're not number one. What was it? The great book, I Am Third. Who was a great running back? Chicago Bears, Gale Sayers. I am third. My creator is first. Others are second. I'm third. And that's why he was a great man, because he lived that concept. Your family is part of the others. They're above you. You serve them, right? And that's what makes you make the better choices when you get mixed up in a crowd like this. Anyway, you've got a great lawyer who's going to help you guide through this, but I am not going to, I would be remiss if I gave you the relief, because these circumstances are most serious and they are most deserving of 180 days upfront time, but could have been life or death row. That's how close this was. I know I sense you can do better. That's a lot of people come in there, they just don't have it. You can do better. And hopefully you're always this will be like a bee sting or like putting your hand on the stove. Never get involved with this because this stings. And then you want to enjoy life, surrounding yourself with your family and doing good things, not hurting people and yourself. Anything else? That is awesome. Thank you.
Finally, this last case centers on Mr. Solomon, a repeat offender who violated his probation and failed to appear in court.
And Langston Adams, we'll start with you. Carl Solomon III.
I believe he's in compliance from my last time.
Oh, that's good. Where is he?
He should be. I hope he outside.
Well, can you get him, please? Thanks.
He just filed the second amendment. He just filed the second amendment.
On the 10th?
Yeah.
And Langston, there's a new motion to revoke probation filed.
Not compliant. Yeah, that's a.
It says failed to participate in drug program.
Oh. You speak. I
Yeah.
thought he did it.
Yeah, but last time we were here, you asked for me to send over the hearing alleging the drug patch violations, which is what I.
So he got the, that's what I mean by being
Well,
compliant.
the point is he's still answerable, but he's not here.
That's easy.
All right. Defendant has failed to appear.
That's all.
There's no answer here in the courtroom, no answer into the hall. Defendant has failed to, what is his bond on this, please?
Released for NPRP with the bank.
All right, then a warrant is issued for his arrest.
That's all him.
And he is, let's see,
That's all.
he's on deferred or unadjudicated probation. So
That's all him.
there's a bond. Bond is $10,000 and a GPS device. But otherwise, how is he doing?
So he's gotten the drug patch, but
That's not him, is it?
No, that's not
Okay.
him.
No, sir. I haven't gotten any results. They don't come in until Friday.
Yes, ma'am. Well, and he's reporting
Yes,
how often?
every month
When's his next?
on the 28th.
If we don't see him sooner, we hope to see him then, I guess. And then it's ironic he's on probation for evading arrest or detention, and now he's evading appearance or detention with us. Been kind of a ironic twist. It's what he is, I guess, the nature of the beast. All right. Well, what else do you have?
That's it.
That's it? Well,
I'll check it out
okay.
later.